Welcome back to the show, everyone. I'm your host, Craig Steger. Happy to introduce you to our guest today. His name is David. Is it Boeg? Boeg?
Boeg, close enough.
All right. David, at least I believe your firm is in New York. I'm not sure where you're recording from, but I met David through, I think it was through the guild, the Maximum Lawyer Guild. I reached out, indicated that I was in some podcast groups and some of these common questions involving copyright, trademark, things like that, concerns that people had both for their own material as well as not wanting to infringe on someone else's rights or material. And so you were kind enough to come on and kind of walk us through that, because this is the type of stuff you do. I don't do any of this. So I'm a lawyer, but I don't know really the first thing about intellectual property. So with that in mind, David, why don't you go ahead and introduce yourself and then we'll start talking.
Sure. Thanks, Craig. Thanks for having me. I'm David. I am the founder of Boeg Law, my eponymous IP practice in New York. We handle all types of patent, trademark, and copyright matters, from applications to cease and desist, litigation, licensing, both plaintiff and defendant side, the whole gamut of anything that touches IP.
And are you practicing in right in New York, or do you work remote, or what's your typical?
Well, right now I'm at what I call the Brooklyn office, which is a co-working space kind of close to home. But
Okay.
I spend a lot of time in the city. You know, we don't have a you're not going to see an office with our name above the door and the receptionist out front. Our team is a bit distributed, which
Right.
Helps us provide efficient services, because it turns out that New York is a really expensive place to run a business. So we're happy to leverage that geographic diversity where we can.
Right. Well, and that sort of segues to maybe kind of an immediate question that I have. So, I'm in Wisconsin. I'm a litigator in the Midwest, so I'm always sensitive about, which state I'm in, and, what am I practicing in a state or not. I'm curious as to IP type stuff, copyright and trademarks. Is that state specific, or is that more of a federal type thing where geographic location, both of the client and you, is not so important?
It really doesn't matter. And it's really great for a law practice, because we can represent clients pretty much anywhere in the country. I mean, I'm admitted in New York. I grew up in New York State. This is our kind of base of operations, but we work with clients literally, all of California, a little in Wisconsin, like everywhere, internationally as well. So it is completely federal. So we are able to help clients pretty much anywhere.
Okay, well, that's very good to know. So I want to give you, maybe if you would, give us sort of the idiot's version of as someone that's an attorney but doesn't practice in this kind of stuff. Can you give us sort of a snapshot of what copyright is, what trademark is, and what those terms mean for the average person that's, let's say, generating some online content or wants to get into that space?
So intellectual property is divided into 3 or maybe 4 buckets. The law provides those buckets to kind of form some sort of bundle of rights around an idea, an expression, a name, things like that. Patent is the bucket where, inventions, things that are novel, devices, methods of doing business, that sort of thing go. Trademarks generally protect brands, slogans, indicators of origin, whether it's a logo, a color scheme in some circumstances, even a sound, but generally we think logos and words. And then copyright protects creative expression, which is the written word, photographs, musical recordings, some types of live performances as well. That goes into the copyright bucket. And then there's trade secret, which is kind of what you keep secret is secret.
And I suspect that the example most of us are least familiar with is music. And so, if you're going to, let's say you're making YouTube content, you can't be playing someone else's music in the background. things like that. Is that sort of what you're talking about?
Yeah, I mean, if you record a piece of music, for example, you have, just by virtue of recording it and having created that, you have some basic copyright rights in that piece of recording. Now, there's layers of in anything we listen to. There was actually a really good, I think it was a Freakonomics podcast a few weeks ago about My Sharona and the layers of copyright that go into that. I mean, there's the person who wrote it, there's the arrangement, there's the recording, the performance. All of those have different levels of copyright. But at a high level, yeah, it's someone else's work. You shouldn't be playing that in your bar, restaurant, in the background. There's some exceptions, but generally that would be copyright infringement.
So, for that to be protected, does it require the artist to go out and, get an official license or copyright, or is it sort of assumed by virtue of you being the creator and putting it out there that people should know that they can't use it simply because of that?
Yeah, you do. There's some formalities in getting a true copyright protection, just by virtue of what they call the fixation requirement, by writing it down, by taking a photograph, by recording it to some sort of medium. You have basic copyright rights in that. You go to the Copyright Office and you get kind of supersized rights that enhance those rights, give you the ability to sue in federal court, get what they call statutory damages, which are damages that are fixed by statute instead of having to prove actual economic harm, some other benefits like that. So we encourage people to go through the law to go and register their copyrights. And it's a good idea.
So if someone has some sort of a content that they've created, but they haven't gone through the formal steps of having it copyrighted, sounds like they may have some sort of enforceable rights to that material, but is that maybe more like a state common law issue? Or
yeah, it is difficult. It's the barriers to entry for a copyright registration are the lowest of the different branches of IP. Patent is probably the highest, trademark the next, and then copyright, the filing fees are low. It's a fairly simple process once you understand, the vagaries of the forms and the different types of applications. It's the type of thing you can do kind of, routinely, quarterly, however often. You've got a podcast, maybe you register it periodically, as an example, or photographs. You take a series of photographs and you register them together. Definitely advisable.
So you and I are sitting here today over Zoom and recording this, and I'll be putting it on my YouTube channel, for example, and I'll share with you. And let's say you decide to use some of this for whatever you want. If I put this on YouTube, sort of what can I expect? And let's say I don't take any further steps to copyright it or whatever, but I just have it out there. It's under my channel on YouTube. If someone else wants to, let's say, listen or share part of it in their podcast, and they're say, here, I want to play a 1-minute snip from Craig's podcast, and then I'm going to comment on it. Which is there anything about that is problematic for them, or things that I should be worried about?
Yeah, I mean, I would leave aside the whatever, YouTube based licensing and policy issues that come up. Just assume that this is just you putting it out there on your own without an intermediary. There are exceptions. Like if you put up the whole episode and copy it, that would be technically copyright infringement. If you don't have a registration on it, however, it's going to be difficult for you to enforce that. It's going to be difficult for you, Craig, to get any kind of damages recovery. If someone just puts it up and uses, say, a minute, we see this on the news all the time. People take clips of things and they put it up on a news broadcast. There's an exception to copyright infringement called fair use. And this is something that people get hung up on a lot, like this idea, it's just fair use. Like it doesn't mean that you think it's, you think it's fair, ergo, you can do what you want. It means that there's a set of criteria that look at, how much have you taken? Is it a commercial use? Are you having any negative impact on the original work? The idea is that, just because you put something out there doesn't mean like you own it exclusive to everybody else. There may be legitimate public policy reasons why we want to let other people take a little sample of that and put it out there. Education, news broadcasting, things like that tend to fall in that category.
we're lawyers, and so at least back in the law school days, we were used to writing papers and citing to stuff. And so in my practice, whether this is right or not, if I'm going to play a clip of someone else's show on my own channel, I will always I'll provide a link to their show. I'll give them credit for that. I don't know if that's making a difference or helping me at all, but does it matter whether I reference them and give them credit in the links as far as fair use, or is that really not part of the equation?
I mean, I think that helps as a practical matter, right? Just out of general respect for someone's work, sure, that helps. From a fair use legal perspective, I mean, maybe I could see an argument that is minimizing the impact you're having on the original work. In fact, you're linking to the original work, you're enhancing it. So yeah, maybe I could see that helping.
Okay. So what,
but just one caution is that there's no hard and, around fair use, there's no hard and fast rules. It is a very case-by-case, fact-specific type of analysis. And really, unless you're doing something kind of educational or in the news category, it's something that you want to really tread lightly on.
Maybe to kind of wrap this up, what I'm hearing from you then is if I use someone else's material in my show, I'm not covering myself simply by linking to them and giving them credit. Like, that doesn't absolve me from any potential responsibility to them or violations of the fair use, right?
That's right. I mean, there isn't like a magic way to handle this. I mean, on the flip side of it, the reality is it's probably, their YouTube probably isn't registered with a copyright. So, the available damages would be very limited. Their ability to sue in federal court would be very limited. So, it works in both directions. It shows you that, like, if you're generating content, it's helpful to go and register it. And if you're borrowing other content, tread carefully and ask permission.
So I've been doing my show here for a few months. I've got a little over 50 episodes, and I'm curious then. So I'm probably at the point where I'm starting to think about, do I want to copyright or trademark this? What the process is? Can you give me some ideas on what factors I should be thinking about in terms of making the decision? Hey, should I go out? Should I hire an attorney? Do I need an attorney to find out well, first of all, do I need an attorney to find out if what I'm doing violates someone else's intellectual property? And I guess second of all, do I need an attorney to go out and actually register it if I want to? And if you're able to tell me, give me an idea what it might cost to do that.
So on the copyright side, it's something you can do by yourself. It's one of those areas it's probably a good idea to get some help, at least the first couple of times you do it. I tell clients that all the time, like, you can hire me to keep filing this every 3 months or whatever, but what we could also do is spend some time on the first couple of them, and I can show you how to do it, because it really is just a registration with the copyright. When it comes to trademarks, though, that's where you can get yourself into a little bit of trouble. With the do-it-yourself approach. Trademarks, remember, cover branding. It's going to cover the name of your podcast, for example. That's a little bit more of an involved process, because you're filing an application with the trademark office. You're asking for exclusive rights to use that name for a certain set of goods or services. And there's an examination process. So there's a back and forth with the examiner, not as rigorous perhaps as a patent, but there are things you can do along the way. And we come in and clean up occasionally on trademark applications that got a little messy, because smart people can make mistakes, because there are things there's areas of law that I hire people for. I don't know everything about everything. So, you kind of have to know what you don't know. And I think trademarks are one area where it does make sense to get help. In terms of cost, it varies widely, because there are different, as there's different levels of service in the legal community. From a very, very hands-off, we will, set you up with our form system and give you 5 minutes of attorney time, to something much more involved and with a lot of hand-holding throughout the way and advice on strategy and things like that. So a good, start to finish, $2,000 probably for a trademark is a is a good bet. There's certainly less costly out there and more expensive, but I think that's a sweet spot for getting some real advice on it.
So, in the trademark, is that something that once you've kind of got it in and it's approved, it's there, it doesn't require ongoing registration, or what's involved in maintaining that?
So it is pretty simple, and trademarks are great because copyrights last an absurdly long period of time, like the life of the author plus X number of years. But trademarks will last forever as long as you keep using them and you do the kind of the renewals, the formalities. So what happens with the trademark? You apply for it, you wait a few months. Right now, it's about 9 months to get an examiner review just because of COVID and a backlog and everything. Unless there's some kind of hiccup, it'll go and it'll publish. So it publishes for public opposition for 30 days. People can weigh in and say, "Oh, wait a minute, this is too close to mine. I'm gonna object to this." So call it, a year, you get through the trademark office, probably a little bit longer right now. After that, there is at roughly the 5-year mark after registration, you have to file what's called a declaration of continued use. You have to show that you're still using the trademark. It's very simple. It's just, it could be a listing from a podcast directory. It could be a product packaging. You just file a document with the trademark office, says, "Yep, I'm still using it. Here's an affidavit," and you're good for another 5 years. And then after that, it's every 10 years. So you do have to, there's some formalities, and, if you've gotten some help along the way to set that up, we remind clients all the time about those formalities because it's important, because if you don't do that, the trademark gets canceled.
Sort of like with, forming an LLC or corporation, it's not a one-time thing. You gotta continue to do those things to enjoy that.
Right, it's modest, but once you put in the effort, they want to make sure that we are giving people the exclusive right in certain brands, and people are kind of pulling language out of general usage for commercial use. We want to make sure that periodically we go and check that they're still using it. And if you don't, it just gets wiped from the register.
So if I'm understanding basically, so trademark is like, let's say my podcast is The Uncharted Catholic Man. If I wanted to register that and keep anyone else from using that term, that's a trademark application, right?
That's a trademark application. And first of all, from a legal perspective, it's a great name, because trademarks are, there's a continuum of trademarks that go from what they call fanciful, which are great trademarks, made up words like Xerox or something like that. I tried to find a podcast example of fanciful and I couldn't come up with one. And then we kind of go down this to like arbitrary, which is using something like Apple for computers. You're applying a real word to something in a kind of arbitrary fashion. And then it kind of goes down suggestive, descriptive, generic. So you want to pick a name that, and there's always a tension, right? With podcasts, especially, you want to describe what it is that your podcast is about. So I think there's, some of them aren't very, like American History Tellers, one of my favorite podcasts, not the strongest trademark name, because it's a little bit descriptive of what they're doing. The Daily is huge, but out of the gate, not the strongest. Really good examples of podcast trademarks, Smartless. That doesn't make a whole lot of sense. It doesn't tell you what they're doing. It's just kind of applied to it. Radiolab, The Moth, those are great podcast names from a trademark perspective. So you want to pick one that is distinctive in the sense that, it fits that criteria at the more inventive end of the spectrum. And then you want to go make sure that nobody's using it, because that's, something critical too. And we look at that for not just, can I register this trademark, but is this something that might infringe someone else's rights?
I think that's a very good point, a very common question that people that are in my group at least have. We're all kind of starting out. We have a hope and a dream. We don't necessarily think we're going to be the next Joe Rogan, but who knows? And so you want to, pick a name. And I think what most of us do is we go, first of all, we see if there's a URL available. And then you search the Apple Podcast name, and you find a little different name, but not always. And, I think people want to pick a name that's distinct, but also want to make sure that they're not picking something that might violate someone else's trademark rights or other intellectual property rights if things take off. So on that end of things, let's say the person is coming in and say, I want to at least try and pick a name that if this takes off and I start to make something of this, I'm not going to run into a problem later on because someone else has sort of rights to that name or theme. Is that type of work that you do for people, is to help consult on the front end and identify potential pitfalls down the road if your program takes off?
Yeah, I mean, that's exactly part of the advice that we provide up front and you should get up front. You want something, you're picking a name because you're thinking, 3 years down the road when you've got 500,000 subscribers and you don't want to have to go and change the name because like the whole, your bread and butter is in that name. So what we do for clearance, and clearance searches have evolved tremendously over the years because like you said, now there's a directory of podcasts. It's relatively easy to see if there's any other podcasts that are out there. So that's one place that you look. Looking at the URL is certainly helpful. The trademark database, once you can figure out some of the nuances to how to search, that's a great resource as well. What we do typically, we actually started working with this AI because AI is the hottest thing ever right now. But we started working with a company that really does apply AI to trademark searches. So it's able to pull from the trademark database. They look at common law usage, like are other people using this just in general commerce, social media, URLs, all that sort of stuff. We look at that because even if someone doesn't have, a registered trademark on the name, their common law use could still be problematic for you. And how problematic really depends on, if you're doing podcasting and they have a restaurant, that's probably not going to be an issue. But, how close can you get to someone else is a nuanced question that merits getting help and advice.
In this type of search, I assume it's something that theoretically a smart person could do on their own, but is there some benefit to hiring someone like you that knows the ins and outs of it and can do a search that's going to provide them with a certain level of confidence that at least right now, this space is available for use?
Yeah, I mean, we do the search as a matter of course. When we file applications, I think it's important to take a look. We have the resources, we have the tools to do it, at hand. So it's very easy for us to do. I think it's important to do for someone, doubles down on a brand. Like, with a lot of things, you could probably do it yourself. I could probably draft my own will, but I'm not going to do that because I'm sure there's some sort of, signature requirement or something that I don't know about and I'm gonna miss it. So it's helpful to get help on this one. I think if it's your brand, so it's worth spending a little bit of resources on it.
Yeah, I think the natural progression for a lot of people is probably something like this. They have this idea, they want to start a podcast. They go out and they're not going to pour their life savings into this, but they're willing to, buy a URL, maybe get into a coaching program, buy your logo and your intro music and stuff like that, but they're not necessarily pouring thousands of dollars into this. Maybe they're hundreds of dollars or something. And so they're like, I'm willing to invest something to have an initial search done, do this, and if it takes off and I'm confident that I've got something here that's going to continue going, okay, now I want to protect my own brand. I want to do it. I think most people probably are going to be reluctant to go right out of the gate before they record their first episode and trademark this thing, because the reality is a lot of us, it either doesn't work out or we give up.
Yeah, I mean, that makes complete sense. Like, I don't know that I would run off and, register a brand until I'd had some sense,
tested the concept a little bit.
Yeah, a little traction to it. But, trademarks are a first come, first serve system with the federal government, at least. So if someone beats you to it, you run the risk of having limited rights at the federal level. I mean, it gets a little complicated because there can be, your common law use in your little area. If I have go back to the restaurant example, if I have a restaurant in my neighborhood, that predates someone else's federal trademark in like the region, I'm still gonna have my little pocket of my little DMZ of use there. So that's one of the reasons that we do clearance searches, is to ferret out those little pockets of use. But you can complicate the situation if you don't register early. People can beat you to it.
Okay. I'd like to ask you a few more questions about copyright, for example. So I've got this podcast, and we're in the 50s right now. I'm not sure how many. In terms of copywriting, let's say can I copyright the name of the show, or am I copywriting each episode? And you mentioned kind of doing a refresh every so often. Can you help me understand how a show that's constantly changing, producing new content, how does copyright fit into that? And what are the things that me as a podcaster should be thinking about doing to protect my content as best I can?
Right. So at a high level, copyright protects creative expression, and there has to be some minimal amount of creativity to it. And that's not, there's no value judgment in the copyright office. It's just, a title of a book isn't copyrightable. A few pages of a book, sure, that's copyrightable written expression. The same thing with your podcast. You're making audio recordings of your program. That recording is copyrightable. So periodically, you could file a copyright registration on every single episode. That might get a little cumbersome. There are certain, we can't go into all of it here, but there are some sort of tricks to filing, en masse, bulk, all under one registration that people do. Instead of filing registration on a photo, you do it on a collection of photos. And you can do the same sort of thing with podcasting, like a series of recordings. So you would do it periodically, every so often you come back to it and register a bunch. That gives you the protection. If someone copies, the whole thing, you really got a cudgel to go after them if that does happen.
I'm going to flip it and ask you a little different question then. So I think for a lot of us, we're not really looking to protect our material. We want people to be freely sharing our material. And I think most, especially when you're on the front end like we are, we want to encourage people to find us and share us. Is there like a disclaimer or thing you could put on there and say, this is not copyrighted, feel free to share, or whatever, that would encourage that?
I mean, software is a great model for that. There's the whole copyleft movement and many, many different types of open source licenses where people release software that specifically says this is out there for everybody to use, and you're free to use it as long as you pay this license for it. That whatever you make with this comes, you could, I assume, you could do something like that, but you could certainly, put it out there. And you're absolutely right. A lot of people don't want to lock it down. You would love it if it was picked up and, I don't know, remixed and repurposed for whatever else people want to do with it. Like it gets it out there.
Right.
That's
if you want to play My Ugly Podcast on your show, go ahead, right?
Right. I mean, the idea behind copyright, the 1776 or 1789 idea of copyright is that we encourage people to create by giving them exclusive rights to monetize their creative expression. You're doing this not because you're able to monetize. I mean, it's not like a direct, maybe there's advertising revenue too when someone does a podcast, but it's a little bit different than, a copy of a book that sells for $20. Like you're putting this out there so people will watch it ultimately.
Right. I want to ask you one other topic, and then I want to let you go because you're busy and I'm busy. But so I know that a lot of the people that are sort of in this space that I'm in are into like kind of coaching and mindset type thing, and are kind of coming up with their own, let's say, 7-step program to help you deal with this issue. And I think a lot of this is sort of repeating concepts that aren't new, but maybe in a little different way. And people are like, okay, this sounds sort of like this guy's program, but it's got my own flavor. Do I need to be worried about that? Am I going to get sued for copyright violations? And I realize this is going to be very fact intensive, but can you give some guidance to people that are creating material that's we're not reinventing the wheel here. We're changing it here and there to fit what I'm doing. Can you provide some guidance to those people, and then, you know, what kind of services you might help them with?
So you're in the guild, you're familiar with traction, I assume.
Mm-hmm.
Traction's a good example where everybody does traction. There's lots of traction consultants. There's lots of people that practice this business growth system. For those that don't know what it is, there's a book, there's a series of books. But what he's done with traction is he's copyrighted, or sorry, he has trademarked EOS. He's probably trademarked traction, some other aspects around the system. So you can't call it EOS unless you have his permission. You can't call it traction unless you have his permission. You can't take, you know, the VTO worksheet and pull out of the book and distribute it on your own,
Right.
But you can take principles of the system and implement those and train people on how to use them. Just don't call it traction, for example. You know,
Right.
You're not going to get a patent on a 7-step method of business growth. It's not going to happen in 2023.
Right.
But what you do have to worry about is what written and recorded work product are you borrowing from this system, and what are you calling it? Because those are the kind of the red flags for me if I'm looking at, you know, how do I avoid a claim from that?
Right. And I think sort of a common nuance, and sort of us that are sort of scrupulous about this are like, well, I had this idea, I put it out there, I write up, and then I start looking around, I see someone else has already kind of maybe beat me to that space. Now they were not the inspiration for what I am, but we kind of reached a similar product independently of each other. Is that something that someone that comes second to the table, so to speak, needs to be worried about?
Well, with copyright, you don't have to worry about it as much. There is, you know, independent creation happens from time to time. People come up with the same guitar riff independently of the other. It does happen. So there's probably, you know, copyright infringement requires some proof of copying. What that actually looks like is for another day, but some evidence of copying. So I wouldn't worry about it too much from a copyright perspective if you know, some of it is the same. Now, if you guys have 6 bullet points that are the same in your system, that's suspicious and like has probably never happened in the history of, you know,
well, since before Chat GPT, right?
Right, exactly. On the trademark side, though, if you call it traction and someone else is using traction, that's going to be a problem no matter whether, you know, it's like a strict liability issue, whether you intended it or not. That's a problem. So
okay, that makes sense. Well, I really appreciate this. Is there anything else? And I'm going to give you a chance to pitch yourself and tell us about how people can get a hold of you. But is there anything about this sort of topic that you're just dying to get off your chest for my listeners about?
No, I was thinking about the trademark perspectives earlier. I mean, the advice, you know, copyright's important, but trademark in the podcast space especially, you know, you want to pick a name that's really distinctive, you know, a good trademark, do it early. You know, the earlier you pick something and run with it, it's going to make your life a lot easier down the road. Really, like, take the time, clear it, make sure it's available. It will make your life a lot easier. Two other things that I thought of that we didn't talk about were, you know, there's this idea of owning the word. Like, you know, like the creators of traction don't own the word traction. What they have are exclusive rights to use the word traction in connection with certain goods and services. That word is, you know, freely available for
a tire manufacturer can use the word
soda, you know, things like that. There's nothing, you know, you don't own it writ large, you own it for your universe. And then the other one that we didn't talk about were international rights. Everything we've talked about here so far is domestic in scope. So trademark, patent, copyright are all territorial. The rights more or less stop at the border. So if you have interests in other countries, you can perfect those rights in other countries as long as you meet certain timelines and things like that. So that's another area to consider.
Excellent. So I'm going to link to your website below, and I guess a question I have for you then is for people that are interested in either looking into your services or if you produce other content. I don't know if you're got a YouTube channel or TikTok or other social media besides your website. Anything else you want to pitch for people that might listen to this?
No, the website is a great way to contact us. My email address should be on there. If not, it's dab@boegip.com. We're always happy to talk to people. We tend to, a lot of what we do is a flat fee model, so we're always happy to chat about what the issues are, and hearing questions from people on the street, so to speak, makes us better at what we do, so we can anticipate it the next time around. So I'm happy to hear from people.
Awesome. Well, thank you, David, for making yourself available. This has been very helpful to me, and I know this is going to help other people. So if anyone reaches out to David through this, make sure that you let them know that this is how you found him, okay? All right. Thanks, David.
Thank you. Thanks
Till
for
next
having
time,
me.
everyone. Have a good one.